Hi, everybody, and welcome back to another episode of Divorce Well in Florida, What to Know Before Your Spouse Does. I'm Matthew Waring, and I'm here with my partner.
I'm Brian Dunmire.
And together we're the partners of Fairway Law Group. We're a Florida divorce law firm. And today we're going to talk about the role of the court in a divorce case. A lot of people don't know they watch TV dramas, they watch movies, they don't know what to expect. They might be concerned that they're going to have to go in front of a judge or in front of a jury and testify. It could be a scary thing. Brian and I are in and out of court weekly. I had a court hearing this morning. We handle them all the time. And, we notice that a lot of people don't understand the role of the court in a divorce case. They don't know if they're going to have to go to trial, if they're going to have to testify at a hearing. So today, we just wanted to speak a little bit to that and provide people with some information so that they are more aware before they begin the divorce process.
Yeah, absolutely. And we'll start off by one of the most common questions that we get asked, whether it's in the initial consultation or at the beginning stages of the case, which is, will I have to go to court? And there's a very clear answer to that. And the answer is probably not. You're probably not going to need to go to court if you and your spouse agree on everything. There's probably not going to be any reason why you would need to go to court. There might be a very small chance that if you do agree on everything, that the judge just wants to see you in person or via Zoom nowadays and just confirm that you are who you are and that you actually want a divorce. So yes, you might need to go to a hearing like that. It's very low stress. That's called an uncontested final hearing. It's very low stress. We would prepare you for everything. We would ask you a few questions. Is this your name? How long have you lived in Florida? Do you really want to be divorced? Is there anything that can save your marriage? Yes, no, bam. Judge signs off on the final judgment. But other than that, kind of going to court in one of these heated contested hearings, the answer is probably not, unless you and your spouse are fighting a lot. If you have a very contentious divorce, yeah, you're probably going to be going to court, maybe multiple times or a couple of times. That's one thing that's a little bit different about family law cases versus, a personal injury case or maybe a construction defect case or something along those lines. Is in those types of cases, a lot of the hearings are done without the actual clients. They're just done by the attorneys. Criminal law courts, kind of the same way. If you have an attorney, a lot of times the actual criminal defendant doesn't have to go to court. But in family law, a lot of times the hearings are going to be what's called evidentiary in nature. And when it's an evidentiary hearing, unless there's a very strategic reason why, you're probably most likely going to have to go to court. But in the vast majority of cases, it never gets to a point that we have to go to some sort of evidentiary hearing or some hearing where the judge has to make a ruling based off of evidence. But it does happen from time to time. And when it does happen, yeah, you will have to go to court. Matt, do you want to talk a little bit about maybe the rules of evidence or what happens at one of these evidentiary hearings, just generally speaking?
Yeah, so a lot of, like Brian said, a lot of the hearings in family law are going to be evidentiary in nature. The difference is when you have an evidentiary hearing, you as a client have to go to that hearing. You have to be prepared to testify. Depending on what the hearing is about, there may or may not be exhibits or evidence that need to be introduced into evidence at the hearing. Ultimately, the judge is going to be making a decision on something at one of these hearings. It could be a temporary parenting plan. It could be to determine temporary spousal support. It could be any variety of issues where the two parties cannot agree. The court has to make a ruling. And that's really the role of the court in divorce cases. To the extent that the clients or the husband and wife or whoever it may be, the spouses cannot agree on something, one party will need to file a motion. Then that motion will need to be set for a hearing. And then the court will then, at the time of the hearing, take evidence, take testimony, and make a decision. It's really important in those situations to know if you are going to win or lose the hearing. If you know that this is a hearing that you just don't have the evidence to win, then that's a good time. That's a good sign that, maybe you want to try to agree and work it out. But to the extent that you have evidence or testimony, including your own testimony, to try to refute the other side's evidence, you might have a shot. And at the end of the day, it'll be up to the judge to decide. That said, you can't just show up to a hearing and say everything that just comes to the top of your head. You can't just, you can't talk about statements that other people made that are not in court, because that would be considered hearsay. You've got a lot of other evidentiary objections. The same evidence code that applies to all civil cases and criminal cases is going to also apply to family law cases. It's also going to apply at these hearings. So, even if you think that you have, a juicy document that is going to win the case if the judge sees it, you might not be able to get that into evidence unless you can find an exception to hearsay for that document. And if there is no hearsay objection, then whoever authored that document is going to need to show up at the hearing to testify. And you might have to issue subpoenas to get people to show up in court and testify. So there's a lot of preparation and legal calculations that are made before these hearings. Now, I will say this: just because a hearing is evidentiary does not mean it's going to be conducted formally. Family law courts in Florida, we've got a lot of different judges. They all do things differently, and some of the judges are more casual than others. Some of them will speak directly to the parties and not even want to hear from the lawyers. Then there's other judges that want to allow the lawyers to present evidence the way they see fit. So it all depends on the judge that you're getting and the jurisdiction that you're in as to how formal a hearing's actually going to be. But we have to prepare for every evidentiary hearing as if it is going to be a formal evidentiary hearing. And if we have any exhibits or evidence that we want to introduce, we have to do the legal research and the preparation in advance to make sure that we have a legal basis according to the evidence code to get it into evidence.
Yeah. And to tag on to what Matt said, there are a lot of different types of hearings. Some are very straightforward and relatively easy and innocuous. The one that comes to mind is family law courts love to have what's called a case management conference. For the most part, case management conferences are pretty standard in nature. The judge just wants to hear what's going on with the case, if a mediation's being scheduled, if there's any sort of discovery disputes going on, or just things of that nature. And those are pretty straightforward hearings. If you have an attorney, different attorneys bill differently, but there's not going to be a ton of preparation that goes into a case management conference. There certainly is some preparation, but can't think of really too many scenarios where you're going to be hit on your bill for 3, 4, or 5 hours of preparation for a case management conference, unless there's some other kind of serious issue going on. And those are pretty straightforward. Typically, the clients don't attend those. There are a few judges that want the clients there, and if the judges want the clients there, then they've got to go there. But usually the attorneys will just handle those. But then you get into the actual motion practice. Hey, I'm taking care of the kids. I don't have any money. My husband is still living in the house, living his best life. I want to live in the house, and I want my husband to pay child support. That's a legitimate motion. That would be one where if we can't come to an agreement with the other side on that we would probably tell you, yeah, it's worth fighting over. And you could even do just a number of cents calculation from the attorney's fees perspective based off of the number of hours that it might take to get to court and do that when you compare that to the child support award that you, in theory, would get. And not that it's about numbers and cents, but that would be something that might be worth fighting over. And a hearing like that is going to be vastly different than a case management conference. That is a hearing where you're looking at, again, it's so hard to say just because it's fact specific, but 1, 2, 3 hours to draft the actual motion itself, depending on the complexities of it, doing some legal research, getting testimony in the form of affidavits or the exhibits, if there's text messages or things of that nature, putting them all together, and then submitting the filing to the court. After you submit the filing to the court, some judges require you to have what's called a good faith conference with the opposing side. And that is kind of a powwow per se to see if you can sing kumbaya together. A lot of times that doesn't occur, but every now and then the case gets worked out or the issue gets worked out during that good faith conference. And then after the good faith conference, you set the matter for hearing. And a hearing like that would probably be a 1 or 2 hour long hearing. And your attorney needs to be prepared for that hearing. And, one of the most frustrating parts about our job is exactly what Matt just touched on, is you never really know what the judge is going to do that day, how they're going to conduct the hearing. Even judges that you're familiar with, that you go in front of all the time. Sometimes the judges just come in and they've read the motion and they've looked at the evidence and they've, I don't want to say already made up their mind, but they know how they're going to rule. They just have a few questions to ask for clarification. Hey, is what you said in the motion true? What date did you move out? Or, where are you working currently? Or what are your wages or whatever? Sometimes the judges just go in there and just have 3 or 4 questions that they want clarification, and then they issue the order. Other times you go in and it's a full-blown hearing. The judge will say, okay, Mr. Dunmire, go ahead and go ahead and put your opening record or your opening argument on the record. And, Miss Opposing Counsel, what's your opening argument? And then, okay, call your first witness. And then, you call the witness and you do this. You ask them questions and they respond. And then if there's another witness, you call the other witness, and it's much more formal. And one of the most frustrating parts of our job is, regardless of how the hearing goes, we have to be prepared for the hearing. Okay, we can't go into a hearing and not be prepared. And getting prepared takes time. Again, every motion is different. Every issue is different. So I can't sit here and tell you, every single motion we need 1 hour for preparation. There might be some motions that I've argued or Matt's argued so many times that we just need to brush up on the facts a little bit, and we're good to go. There could be other motions that we haven't had that very specific issue before, or it's a very novel or complex issue that has some very fact specific and case law and statutes that apply. And it might take several hours for us to prepare for the hearing. And we have to be prepared for these hearings, because if you go in, the one hearing you're not prepared for, if you go in there, you're going to get caught with your pants down. The judge is going to know you're not prepared, and it's going to be all for naught. However, when you are prepared for the hearing, inevitably those are always the ones where the judge says, I'm going to rule this way. And then sometimes the clients, in hindsight, scratch your head and say, why am I billed all this time for you to prepare for the hearing? I was at the hearing. It was a 15-minute long hearing, and it didn't seem all that complex. And it's part of what we do. It's part of how we have to handle the cases, because we have to be prepared for those hearings. And we need to know what's going to happen or what arguments to make. And the more complex the issue, the more time it's going to take to prepare for the hearings. And then to kind of just shift gears a little bit, sometimes people think that going in front of a judge is going to ultimately get them the exact outcome that they want, because how can the judge disagree with my view? And what Matt and I found over the years in family law is that there are always going to be 2 sides to the story, whether or not they're valid or not. I'm not saying that they are valid. I'm not saying both sides are valid. I'm not saying one side's valid, one side's invalid. I'm just saying there's always going to be two sides to the story. And just because you think what your ex-wife or ex-husband did is the worst thing possible, and you don't understand how a judge can't rule in your favor, doesn't mean that the judge is going to see it that way. I've had, and any attorney will tell you this, I've had hearings and motions and cases that I thought there'd be absolutely no chance that I could lose. and then I end up losing them. And then I've had hearings and motions that I pretty much was certain we were going to lose, and then we end up winning them for whatever reason. And it's, don't just assume because you think that you're in the right that the judge is going to necessarily agree that you are. Judges try to do their best. They try to be fair. They try to apply the law, but that doesn't always mean that they get it right. Or they might view the application of the law a little bit different as a client, even if you understand what the factors of the best interest of the child are. A judge may view them just a touch differently, or much differently, and ultimately not rule in your favor, or give a ruling that you're not happy with, that wasn't the outcome that you wanted. And this is why, if you listen to any of our podcasts, why I'm always saying the best thing you can possibly do is work it out amongst yourselves. Of course, with our assistance, I'm not suggesting that you just go figure it out by any stretch of the imagination, but work it out, amongst yourselves, because even if you don't get every single thing that you want, you're going to feel a lot better about that result than if you go in front of a judge and the judge just essentially says, "No, I'm not dealing with this today," or "No, I'm not going to grant the motion because I don't think there's anything wrong with your husband continuing to live in the house. He needs a place to live, and you've got a 2-bedroom apartment. Why should we kick your husband out of the house?" It's not a good scenario to be in. So it's kind of one of those, to quote the Kenny Rogers song, "Know when to hold them, know when to fold them." There are certainly times when you absolutely need to take a shot and go for a hearing, no question. And any attorney who tells you otherwise is I would disagree with. But there are also a lot of times where it just might not be an issue that's worth going to a hearing on, just for a variety of reasons. I know I get a lot of phone calls where somebody's complaining about maybe a cell phone bill that didn't get paid or something. And, could you go to a hearing? Yeah, absolutely. Is it worth spending, 2 hours of attorney time to draft a motion, prepare for that hearing, attend the hearing, and then a lot of times after the hearing, the judges have the attorneys actually write the orders for them, writing the proposed order? I don't know that a $40 a month cell phone bill is worth that. I think you just got to suck it up and figure it out.
And just from a practical aspect, another issue is anytime you want to force another party to do something, you're going to need a court order. And the only way to get a court order is to go to a hearing. And the only way to go to a hearing is to file a motion. So typically what happens in any case is an issue arises where one spouse needs to force the other spouse to do something. Maybe one spouse is not complying with mandatory disclosure and not disclosing their financial documents. So what do you need to do? If they're not doing it, your whole case is going to get stuck because you can't settle the case if you haven't got their financial disclosures. And so the whole case is held up. You have to stay married, even though you don't want to be. You want to be divorced, but you got to stay married until your spouse provides the information. How do you force your spouse to do that? You have to file a motion to compel your spouse to comply with mandatory disclosure. So your lawyer would have to draft that motion, file it, and then get it set for hearing. And guess what? Hearing time is extremely hard to get. Judges have tons of cases. A lot of cases. Hundreds, if not close to 1,000 cases, depending on the judge. And they have trials, they have case management conferences, they have hearings. There's a lot of things that they're doing on the cases. And they only have so much hearing time available every month. So you're competing with all of these other cases to get that hearing time. It is not unusual at all to file a motion and not be able to get a hearing for 2 to 3 months. Again, it differs by judge, and it differs on the amount of time you need for the hearing. So if it's a very simple hearing, for example, a hearing on that motion to compel your spouse to comply with mandatory disclosure, that's something that only is going to take about 5 minutes. You're going to show up at the your lawyer's going to show up at the hearing. On March 15th, the disclosures were due. It's April 15th, and we still don't have the disclosures. We're seeking an order to compel the other party to provide disclosures within 10 days. Very simple. The judge is going to grant that motion. Okay? You're going to get a court order, and you're going to force a spouse to do something. You might be able to get a hearing on that relatively quickly. And by relatively quickly, I mean within 30 days. That would be quick to get a hearing set. However, if you have a motion for exclusive use and possession of the marital home and for an interim partial equitable distribution, and that's going to be an evidentiary hearing, and you're going to need probably 2 hours for that hearing, at least 1 hour, but probably 2. The next available 2-hour block of hearing time for that judge might be in 90 days. However, you might be able to go to mediation on your case and completely settle the case and resolve all the issues and get divorced before you even can get to that 90th day to have that hearing. So in family law, any divorce cases, there is a cost-benefit analysis that we do before filing any type of motion. And that cost-benefit analysis looks like this. If we file this motion, do we think that we can get a hearing on it before a mediation? If so, then it might be worth filing the motion. If not, it might still be worth filing the motion, but it might not be worth setting it for hearing if there's a mediation coming up. We also have to look at the costs. How much is it going to cost? Like Brian talked about earlier, does the benefit to filing the motion and having it heard outweigh the costs? Depending on the situation, it may or may not be worth it. That's obviously a conversation that you have with your attorney. But the big takeaway is that, well, two things really. Number one is to force your spouse to do anything. Some examples: to continue to pay the mortgage, to, comply with deadlines, to force a spouse outside of the home, temporary time sharing with the children. Maybe you're getting divorced and your spouse has the kids and they're not letting you see the kids, and you moved out of the house and you'd really like to see your kids at least on weekends, but your spouse is not offering to allow you to see the kids. Well, you got to force your spouse to let you see the kids. You have to file a motion to do that. So that's number one. Number two is it can take a really long time to have your motion heard. So this is not a thing where you can file the motion and be at a hearing next week on the issue. That happens very rarely, and typically only when the motion is an emergency motion. And what qualifies as an emergency to the court is a lot different than what qualifies as an emergency for you. For you, an emergency would be, my husband makes all the money, he stopped paying the mortgage, my house is going to be foreclosed on. That is a personal emergency. That is not a court emergency. A court is not going to hear that on an expedited basis. Court emergencies are really just to protect somebody from physical harm, and more specifically, children. So if children are in threat of imminent physical danger, that would be considered an emergency court motion. You could file that motion if you got the facts to support it. You could file that motion today and have a hearing the next day a lot of times, because the judges will have certain times reserved almost on a daily basis to hear emergency hearings. But again, what you consider emergency, it's not going to be the same thing as what the court considers an emergency.
Yeah, and getting the hearing time is also much more complex than it seems. Even to myself as an attorney, somebody who's done it hundreds of times throughout, hundreds of cases, maybe thousands at this point, it still baffles me with how complex it is to set hearings. Because if you go back to what I said at the beginning and what Matt and I were speaking about, if you do go to a hearing, a lot of times the clients have to show up in family law. So when that happens, that means you got to get a hearing date. Number one, you got the dates that the judges are available. That's the most important. Then number two, the attorneys, both attorneys are going to have to be available, our office and the other office. And then third, the clients need to be available. Now, I will say typically, clients are pretty good at understanding if there's a hearing, you got to do what you can to make it work. I personally would ask that, if you have a hair appointment that day or something like that, to cancel it and reschedule it or something along those lines. But, obviously if you have some sort of, heart surgery that you're going into, then you're not going to be able to go to the hearing. That's certainly understandable. But just getting the dates that the judges are available, sometimes those dates, we sit here in April as we're recording this podcast, a judge might not be available until, say, May 20th for a relatively simple, straightforward motion. So, the judge responds back, or their website says, okay, we've got May 20th, May 23rd, and June 7th available for a hearing. And, well, I might have a trial on May 20th, and so I'm only available for the other 2 days. And then the opposing counsel might have a trial for the other 2 days. And that happens all the time. And most attorneys are usually pretty good when it comes to scheduling, being honest. Hey, yes, I am available this day, or I'm not. But there are times when it's just, none of the days work, so we got to get more days. And then, you're looking out into the middle of June or late June or something like that as we sit here today in April. So you're looking at 60 days out for some sort of hearing on something. And so let's say your hearing gets set for June 20th. That's 2 months from when we're recording this podcast. I mean, if it's not an important issue to you, do you really want to wait that long to get a resolution on it? If it's not something, that is, very meaningful to you. And exactly what Matt said, just because something's urgent or an emergency to you doesn't mean that a judge is going to view it that way. Generally speaking, emergencies are exactly what Matt said, threats to bodily injury, legitimate threats of bodily injury, not perceived threats of bodily injury. Not, hey, my husband drinks a little bit too much and I'm nervous that something bad's going to happen with the kids. That could be a very valid concern. I'm not doubting that or downplaying it by any stretch of the imagination. But that's not going to rise to the level of getting an emergency hearing because it hasn't happened in the past. And this is where it starts to get real difficult for us because we don't really want to ever encourage our clients to call the police or create a domestic disturbance or call anything in like that. But at the same time, if there's no police record, is it how much of an emergency is it? I mean, if DCF isn't being called, how much of an emergency really is it? And that's how judges are going to view it. I mean, look, if there's a police record that comes out and says, on this date, I went to the premises and I found the spouse and disposition, just obliterated, drunk. They'd obviously, broken a bunch of stuff in the kitchen. The kids were crying. The kids were upset. It doesn't look like they've been fed. I mean, yeah, you're going to get in front of a judge pretty darn quickly because, you did what you needed to in that instance. You called the police to try and rectify the situation and you got an emergency situation on your hands. If it's your spouse is just getting drunk and you don't like it, and you're nervous or something along those lines, I mean, you're going to be stuck on the regular hearing docket and you might not get in front of a judge for a month or two. And I'm not here to tell you whether or not that's right or wrong. I mean, that's a personal opinion, but that just is the world that we live in. The courts don't really move that quickly here. And so sometimes it takes a very long time to get in front of the judges and to try and get these issues worked out. So that's definitely something to take into account when trying to determine whether or not you should proceed to the court, proceed on a motion or something along those lines.
Yeah. So there's a lot of, cost benefit as far as actual, spending the money on attorney fees to file a motion, go to a hearing, get a court order. There's also a cost benefit analysis to be done on, is this an issue that is worth waiting on? Is it worth stalling the entire case in order to have this one issue heard? And certainly in a lot of cases, there are those issues where, yes, it passes both cost benefits analysis. It's worth it to spend the money to draft it, file it, attend the hearing, and it's also worth it to have the motion, to wait on the case, to have this motion heard. It's that important. There are certainly those things that pop up in the cases, but you definitely, we do it on all of our cases. We do it with our clients, before we're filing motions. We think about it, and we have those, we do those cost benefit analyses to try to do what's fair for the clients, to try to get them the best results possible in their divorce case. But it really just comes down to a judgment call a lot of times. So, the best thing to do is, if you're working with a lawyer on a divorce case, is, to bring up concerns timely, and, hear what your lawyer has to say about, whether or not they think it's necessary or a prudent decision to file a motion on that specific issue, or at least go through those cost-benefit analyses to see if it's actually worth having a hearing on any issue. But assuming it is, we've kind of discussed the process, how we would draft a motion. A lot of times the motions are going to be evidentiary in nature, meaning that as the client, you're going to have to sign off on the motion, that you've read it, reviewed it, and that you're going to testify to the same facts that are in that motion. That motion then gets filed with the court. And then your lawyer will proceed to try to set it for hearing, try to find some hearing time. Like Brian already discussed, it's got to be coordinated. The hearing time's got to be coordinated with lawyers for both parties. And obviously that opens up another problem. The other side's lawyer might just always be unavailable. Just, real busy guy, just never has any time, can't go to a hearing. And they do that on purpose. They do that to sandbag your motion, to try to prevent it from being heard. And guess what? In order to deal with that, if we think that it's done improperly and that they're just stalling, there's another motion that needs to be filed to prove that. And then that motion also has to be set for hearing. So it's kind of circular. So assuming that we can coordinate dates with the opposing party, then as Brian talked about originally, before we can actually go to the hearing, we have to do a good faith conference with the other attorney. Got to pick up the phone, got to talk to them, see if we can work out the issues. If we can, great, cancel the hearing. If we can't, then you leave the hearing as scheduled. And then, both sides will prepare for the hearing, show up, offer exhibits, offer testimony, offer evidence, argue the law, and then the judge makes a decision. It's very helpful to know what your merits are, whether or not you're going to, what your chances of succeeding on the motion are before you're filing it. Surely you don't want to incur the costs and spend the time, filing a motion, preparing for a hearing that you have a very low chance of succeeding on. That wouldn't make sense to do that. You really just want to file a motion when you know that you're right and you know that they're wrong, but you need the court to intervene to force somebody to do something or to not do something. That's really when we're filing hearings in family law cases, or filing motions in family law cases.
Yeah. All right. Well, that will conclude this episode of Divorce Well in Florida, what to know before your spouse does. Again, my name is Brian Dunmire. I am one of the managing partners at Fairway Law Group, a Florida divorce law firm. My office is located in Orlando, and Matt Waring is the other managing partner, and his office is located in Deerfield Beach. So if you're going through a divorce or contemplating going through a divorce, please give us a call. We would love to chat with you and see if it's something that we can help out with.